So let's talk now about a bad faith rescission. We'll dive a little deeper into what that might be. It's important to not confuse a rescission of a policy with a denial of a claim to defend or indemnify. The denial of a claim is when you have tendered a claim under the policy and the insurance company has looked at the coverage and said the claim doesn't fall within the coverage. The policy continues to exist. You can make another claim, or another claim, or another claim. Let's hope you don't have that many. Under the same policy, and there is an opportunity for coverage. Just because they have denied one doesn't mean that they have rescinded the policy. When you have a rescission of a policy, that's a very different thing. That's when the insurance company has looked at the policy and looked at the application that you submitted when you got the policy. It's called post-claim underwriting. And when an insurance carrier does post-claim underwriting and issues a rescission of the policy, they give you your premium back and they tell you you've got no coverage at all. Not for that claim, not for any other claim, policy gone. Post-claim underwriting is a bad faith act. They're not allowed to do that. If you've lied in an application, that's fraud, and they can rescind a policy for that reason. But it's really, really dangerous for an insurance company to go down that road unless they've got it spot on. Now, let's talk about what the result to you is if you have a rescinded policy at any period of time. Let's pretend that you were first licensed and started business in 1978, and you got your first E&O policy the day you opened your doors. And you've had E&O coverage all the way along. Each time you get a new policy, year after year after year, you get what is also called past acts coverage. That means that if you have a claim that arose from a transaction back in 1979, and assuming that the statute of limitations could be met and all that good stuff, your current policy would cover that claim because your prior act's endorsement would go all the way back to the very first day that you had insurance. If you have a break in your insurance coverage at any one time, you can only get past act coverage to the beginning of the new period of insurance. So you don't get past act coverage to 1978. Is that important? Again, let's pretend. It's 2012. You were in the loan origination business as a real estate broker in 2004, 5, 6, and 7, back in the go-go days. Now, as you know, every lender in the world is bringing claims against the brokers and the banks and the borrowers for negligence or intentional misconduct in lying on those loan applications. Let's say that you have a policy, you tender a claim, the insurance carrier rescinds the policy. You go off and get a new coverage from a different carrier, and then 3 days later you get sued on another claim from 2005. And your new insurance carrier, who had the first coverage in 2012, after that break in coverage in 2012, tells you you've got no prior acts coverage. And so even though it's a pure negligence claim and would otherwise be covered, there is no duty of an insurance company to cover that prior claim. That's the risk of a rescission of a policy. That's why post-claim underwriting is generally not allowed. If you think I'm making this up, let me give you an example. A real estate broker has an agent. The agent, not such a good one. A client buys 5 or 6 or 7 different pieces of property, all within that same 2005, 6, 7, 8, 9 period of time. Each property is lost at foreclosure. Each property has claims from tenants, from skimmed rent. Each property has got the real estate agent that is taking the proceeds of insurance claims, taking the rent, converting money, going and getting lines of credit on behalf of the client, taking all of the money from the line of credit and letting the client pay. The client sues the brokerage. The insurance company tenders a defense for both the agent and the broker because there are negligence claims made in the complaint. 10 days before trial, the insurance company gets a settlement statement and learns for the first time that the agent had had a DRE audit, not an accusation. No complaint was filed, merely an audit. The insurance company rescinded the policy on the broker's part, which included the agent, because it wasn't written that there had been an investigation, an audit, in the insurance application, even though the insurance application never asked if there was an audit. It asked if there were claims, and it defined claims as a demand for money by a customer. Is the DRE a customer? No. Is an investigation a demand for a claim? No. But the insurance company said the broker lied in the application, rescinded the policy. The client went to trial against the real estate broker and got a settlement the day of trial for $1.6 million. The insurance policy only covered $300,000. The broker was out to dry. The broker made a claim against the insurance company for bad faith rescission and settled that claim months after making it. The customer was covered, the broker got covered, and the insurance company got what it deserved. The point of this story is bad faith rescissions happen all the time. All the time. When it happens, or if it happens to you, contact somebody that knows what they're doing to help protect your rights. Call us.